So good morning, everybody who is present. We are here. I don't know. Oh, there we go. That's much better. For the policy meeting, there's 4 areas that we're going to be covering today. I'll just kind of give you a heads up. We're going to talk about the criminal justice population projections, and Brett Miller is going to do the presentation on that. The next thing we're going to discuss are just some issues with the JRI-2 regarding certification and compliance. Mark and Ryan are going to address that collectively. The third issue is just talking about the academic review panel, which is chaired by Judge Tucker, and some exciting things that are going on with that. And then finally, the parole guidelines and recommitment ranges, some new things that have come up regarding that and the tools and where that stands. So the first thing we'll start off with, if you're ready, Brett, is the criminal justice population projection presentation.
Yep, I'm ready. Good morning, everyone. Let me just share my screen. Sorry, I don't know if you can see that on your end, but it's taken a second on my end. Okay, so I just wanted to catch everyone up on some of the work that we've been doing in research and analysis to try to sort of enhance our capabilities for population projections. And this is especially something we've been working on over these last 9 months or so during this work from home period. So it's been a good opportunity for us to sort of upgrade some of our capabilities on the back end. So we've got a lot of statutory mandates that sort of describe what the commission's functions are. Obviously, primarily is setting sentencing guidelines and collecting data related to those. But we've also got, a big part of what we do in research analysis is providing impact analysis for legislative members, providing data sets, and sometimes doing analysis for external requesters as well. So going down the line of all the different ways that the mandates lay out for us to do those projections, at the end, it very specifically mentions simulation models. So this is something we haven't really had the capability to do in the past, but like I said, these last 9 months have been a real good opportunity to catch up on some of these things. So the mandates say the commission shall use a correctional population simulation model to determine, number 1, resources required under current guidelines, and any other risk assessments, any other products that the commission has published. And then the models should also be able to take a look at proposed changes to guidelines, legislation, or just any proposed changes to sort of the underlying structure of how the court system works in Pennsylvania. So 2 years ago, we received a grant from the CJPPC for 2 years to develop these models. Sorry, Christy, I'm seeing the images of everyone on the right side, and I can't actually see the slides. I don't know if there's any way I can.
So if you go up, there should be a view in the upper right corner. And try changing that to say side-by-side speaker. Are you seeing that?
I think I've got it good enough here.
Okay.
So as I said, we received a grant to develop these models. We selected Simulate software to build the models in. So Simulate is an international company based out of Scotland. They're sort of the industry leaders when it comes to these big system simulation models. So the way Simulate works is it sort of creates a flow diagram of whatever system you're trying to model to try to mimic how the system works. So for us, that would be various parts of the criminal justice system, whether it's the court systems or even zeroing in on something more specific like probation or parole. We use user knowledge of the systems to build in rules or logic to show how items can progress from one step to the next. And then we fill in the details using historical data to model the likelihood of each possible event. So I think this will make a little more sense if I get into some of the models. So we've created 4 separate models. The first one being early forecasting of sentences. So basically what our traditional method has been, if we're creating an impact analysis on sentencing alternatives, all we can really go off of is our own sentencing data. So if we're seeing an increase in sentences coming in into our data, then we're already a little bit behind the 8 ball because the increase has already happened. So what we were wondering is if we sort of zoom out on the court process, take a look earlier, going all the way back to MDJ and municipal courts. If we can look for trends that are happening back a few steps at that level, then we should be able to project, 2 months, 3 months ahead of time for what's going to happen at common pleas, with sentencing at common pleas. So that's the idea of this first model. We used data sets from a number of different sources, our own data, but also from AOPC, DOC, and for some of the models, even some data from the parole board. So in module 1, we're first starting looking at cases as they come in and get filed at the MDJ MC level. So essentially right after arrest. And then we follow those cases through the court systems. And we account for any attrition in those cases that happen along the way. So for example, at the beginning, we start with, if you start with 100 cases, maybe 20 of those drop off to a plea deal at MDJ disposition, maybe another 30 are held for court and move on to common pleas. And then at common pleas, again, you've got more attrition before you finally get to sentencing. So that's sort of the idea behind this model. What I have here is just sort of a screen capture of what that model actually looks like within the software. So I apologize if this is small on your side. You don't necessarily need to be able to see every detail, but just to give you an idea, on the left-hand side, we have new cases being filed at MDJ, and we've got them split up into different offense types. So violent, sex, property, pretty generic buckets there. And then we're actually modeling how long these cases take as well. So this red bucket on the left-hand side, that's all the cases that are waiting to be disposed of at MDJ. And then in terms of attrition, there's a few different ways that cases can drop out at the MDJ level. So some cases can be acquitted, guilty, held for court, et cetera. Once they're held for court again, we've got another area where they've got to wait to actually be seen at court. So we model that time as well. And finally, they make it to common pleas, first in disposition, and if they're guilty, then we simulate a sentencing process. So essentially what we're hoping to do with this model is, like I said, zoom out and take the big picture look. And what we can do is, if all of a sudden we notice that there's been a spike in new violent cases being filed at MDJ, we can say, okay, we expect that in 6 months' time, we should see a similar spike at sentencing at common pleas and theoretically at state prison sentencing as well, state prison admissions. So that's what we're trying to use to provide information to legislative members, and in this case specifically to DOC. We've actually been using this model for the last year or two to help out Brett Buckland at DOC with state admission projections. And what we've been able to find that he thought was pretty useful too is we were able to sort of predict ahead of time that there's sort of a steady 3% droppage in state admissions that's been happening over the last 2 or 3 years. That just having that knowledge was able to help out with their projections as well. And then the other nice thing about this software is it's very modular, very flexible. So if all of a sudden we decide we don't want to look at just these 7 or 8 buckets of offense types, we want to look at 15 offense types. All it takes is a few mouse clicks and we can add those into our model. Same thing on the sentencing side. If we want to add or remove sentencing alternatives, we can add those in very easily. And then the process for actually running these models, typically first we'll run it for maybe a 3 to 5 year period to get a good average. And we would run the model overnight to get those results. And then if we had a specific question we're trying to answer, like for example, violent M1s, what happens if they spike by 15%? Well, we can run that scenario, change the rates in the model, then run that again overnight and get some results out within a couple days time. The idea is we'll refresh the background data that builds these models probably every 6 months to every year. And then I don't think I mentioned, at any of these steps, the way things are decided, where they go, like for example, MTJ dispositions have 4 different options. And those are all based off of historical trends. So we know that 25% of the time, a property case will get acquitted at MTJ, for example. So this is module 1 of our 4 modules. I'll talk quickly about module 2 here. Module 2 is really zooming in on the actual sentencing guidelines and looking at a lot more specific details in terms of a case. So determining what impact the sentencing guidelines themselves have on not just sentencing alternative, but also sentencing lengths. So in this model, we put in all the details, the sentencing matrix, statutory maxes, mandatory minimums. We've really got all the details inside of this model to really look at very specific examples for sentencing questions. So the way this model works, we're sort of starting at the common pleas sentencing phase in this model. Cases come in, we assign them very specific case details. So not just the 7 offense types from module 1, but in this case, we've got 75 different possible offense types. We combine that with a grade of offense, assign a PRS score, OGS, and then using that information sort of run it through the sentencing guidelines model and see what the resulting sentencing alternative would have been, and also what the resulting length of sentence would have been for that simulated case. So here's just an idea of what module 2 looks like. I'd say this is probably the model that we will use the most in-house, looking at any possible bumps up in OGS scores for certain offense types, any possible changes to the way that PRS works, which is something we'll be talking about later. But all those things can be modeled in here and really give us insights into things that we couldn't really test out before. So in this model, like I said, new cases come in on the left. We assign a grade, offense gravity score, then PRS, and these things are all based on what type of offense it is. They have different rates for the PRS score that would typically be associated with each of those case types. And then when you get to sentencing, this is where it's really getting into all the details of the sentencing grid. And then we just simplified it into 4 sentencing alternatives for this model: state prison, county jail, probation, or other restorative sanctions. And for those cases that get assigned to state prison, like I said, we're using the guidelines to assign them a minimum sentence and a maximum sentence that's based off of looking at the upper and lower boundaries of the guideline matrix. And now I just wanted to show a quick example of what we can do with Module 2 in terms of running an actual scenario for an impact analysis. So I just did a quick example here where if we take all identity theft offenses and increase their OGS by 1, what would happen to sentencing alternatives handed out for those cases, and also what would happen to the length of sentences. So on the left, the left is based off of the baseline model. So this is just the way that things have been sentenced over the past 2 to 3 years. Like I said, I simulated 1 year. Identity theft is a pretty low offense in terms of numbers. So we ended up with, I think, about 175 identity theft cases in the simulated year. Most of those go to probation under the current baseline, with about a third or so going to county jail and about 20% going to state prison. Now on the right side is our scenario where we bumped up OGS by 1 for each identity theft offense. And you can see there's a pretty big shift in types of sentences handed out. So probation is still the most, but now it's less than 50% that go to probation. And it's really evened out now between county jail and state prison. So like I said, there was 175 cases. The way I ran this is I ran the exact same cases through for our scenario. So out of those exact same 175 cases, we went from 34 state prison sentences up to 50. So almost a 50% increase in sentences going to state prison. Now, if we look at those state prison sentences and the average minimum sentence, model for the baseline showed us that they got an average minimum sentence of 14.6 months. Now, by bumping up the OGS score, all of a sudden we tack on an extra 4 months to that average minimum sentence. So all in all, this doesn't seem like a lot, only 175 cases. Only, even in the new scenario, only 50 cases got sent to state prison. Only 16 extra from before, and only 4 months got tacked on to the minimum sentence. So it doesn't seem like much when you look at it that way. When you combine the fact that we've got extra sentences going to state prison with the extra sentence length, what you end up with in terms of resource utilization at the DOC side, we've got almost double the number of prison bed days that would be assigned in this scenario. Like I said, that's just the compounding factor of 50% more prison sentences and an extra 4 months onto all of those sentences. So an increase of 13,000 prison bed days. So that's a pretty serious load to add on to DOC resources. Modules 3 and 4, I'll just touch on real quick here, but module 3 is on state parole and recommitment ranges. So basically this is modeling the really specific timing of sentences as they're being served in state prison, modeling when offenders are eligible for parole interviews, and then modeling their actual supervision time when they're granted parole, how often they're going to violate or even revocate on their parole. Module 4 is very similar to that, except for probation and resentencing. So again, we look at all probation sentences and then model any revocations or resentencing. So possible things we can do with this in the future. Again, we've we've really ramped this up just in the last few months here, and kind of going into the new years will be the first chance we get to actually start using these models. Some possible things we can add in, cost benefit analysis. So for example, that prison bed days example, we can add in the actual costs associated with that for DOC and see what that impact is. We could potentially in the future add in caseloads by county or even county classifications or regions, because there is a lot of difference from region to region within Pennsylvania. And finally, another thing we can look at is modeling the numbers and the eligibility rates for various DOC programs. So triple RI, state drug treatment program, short sentence parole, et cetera, et cetera. So that's basically where we're at right now in terms of population projections and simulation models. We can open it up for any questions.
Brett, I'm just curious, how is it difficult to populate this from the counties, the information that's coming in? I'm curious how fluid that is.
In terms of the county level, that would take a lot of legwork up front. It's easy to put it into the actual software, but the hard part is the data collection.
Right.
And
is there a model
the quality of data from one county to the next is not always the same.
Right.
Brett, what is the overall purpose of this study? I think I missed it, or I didn't quite understand.
And the overall purpose is anytime we're considering making any changes to either the guidelines or any legislative changes to the sentencing process. This gives us an example to, we know what our current state is. This gives us an example to look at the potential of what the new state would be. So like I showed in the example, if we decide to increase OGS scores for a certain type of offense, it gives us a chance to say what the real impact is going to be in terms of state prison sentences, or even the load on probation, things like that. So I think it really gives us a clearer picture of the ultimate load on the system throughout the state.
Hey, Brad, if I could add, and Judge, there's sort of two statutory requirements. One is the commission is on the Criminal Justice Population Projection Committee. It's a state committee that involves us, the Department of Corrections, the Parole Board, and we work with the Budget Office and the Policy Office of the Governor's Office. And we sort of collectively come up with projections that are used annually for estimates for the budget and for correctional populations. So we, as sort of a team with PCCD, do that kind of high level forecasting so that for budget purposes, there can be a plan as to capacity and things like that. And then separately under our legislation, we're required to assess the impact, the resources required if we make any changes to the guidelines. And since we are both, our current focus is on sentencing guidelines, but our expanded focus is on parole and recommitment and resentencing, we have to have the capacity to be able to do forecasting or projections in all of those scenarios. And it's whether there's a change in statute or there's a change in the guidelines, we have to be able to have some sense of the impact of that. And then the final thing that Brett mentioned as far as sort of a future opportunity is that it's a lot better if you can talk about the costs and benefits of things, where you can sort of apply specific costs to successful outcomes or failures and the use of resources. And so trying to use this kind of integrated model to look at the whole system and the flow of things gives us an opportunity to sort of assist the legislature and the governor's office in trying to estimate costs and estimate populations.
would it be accurate to say that the various counties will have various input in terms of the time between arrest and sentencing? And how do you get that? How do you get to the medium, if you will, of that and using these modules?
Yeah, you're definitely right about that. In fact, we haven't even tried to model the county by county effect at this point. The way we've built these models so far is just taking the state as a whole and using the overall rates and the overall timing for the state as a whole. But you're right, there's huge variance from county to county.
Thank you.
Hey, Brett, just on that issue, your model takes that into account to some degree by just the sort of the distribution of cases that come in and move through the model, right? So although you don't have it broken out by county specifically, that's one of the factors that would be part of the modeling, right?
Sure, we take into account the differences between, what we found is property offenses specifically tend to take a long time at the MDJ level for whatever reason. So we model that into the system. So if you look at the cases that are waiting to be seen at MDJ, you'll get a high load of those being minor property offenses, things like that. So it's just one way where we're modeling in some of the actual variation that is happening.
And there's one other, I guess, opportunity, Judge, and this has to do with a project that the commission's been engaged with for a number of years, but actually is managing a grant right now to try to update the service, and it's called electronic reporting. There's a mechanism through JNet where county probation departments can report sentences or caseloads to the state, and that county jails can do the same to the state. And there's an opportunity there as long as we can rely on the data. And one of the problems was, each county has their own case management systems and other things like that in place. And there were some problems with how those data were being reported, accuracy issues, duplications, things like that. But we've been managing this grant that helps counties to refresh their application and put in place this new software, basically that's much more accurate in terms of a daily reporting of cases up to the state, and eventually that should give us a better opportunity to know something about county-specific information rather than just sort of aggregate or statewide data. So our focus has been on like the impact on the Department of Corrections or the parole board, sort of at the state level. And then at the county level, we just sort of throw everything together. And you're absolutely right. Every county is different. And so if we can really exploit that information that's available through that electronic reporting system, we may be able to do a lot better work at the county level. So thanks for raising the question.
The other question I had is going back to module 1. If you wind this out through the course of the, I guess you mentioned 3 to 5 years. My thought is, do you have any concern that this information will be obsolete by the time you get to the end of it? Say 5 years from now, if you started today, 5 years from now, would it really be, it may not even be relevant. I mean, we may have moved on to another thought pattern or something completely different. Has that been given any consideration?
That's a really good question. And that's something we ran into when, especially with that module, when trying to decide how long to go back to find these trends. What we found is I initially used, I think, 6 years, and the data didn't make any sense compared to what DOC was seeing in terms of admissions. It was way too high. What we found out was there were a lot of major legislative changes that happened during that time period. Mandatory minimums going away, various other things changing. So I really had to narrow the scope of how far back I was going to build that baseline data. So I think in the end, we're using either the last to maybe 3 years to build the baseline. And even then, you do run the risk of, if there's any major changes in legislation, you've got to be aware of it and try to account for it.
And Judge, on that point, we've had discussions also. I mean, exactly the issue that you've raised. To some degree, you're updating the model, hopefully every year, to take a more recent year of data and drop an older year of data, so you can see how that's sort of progressing and sort of keeping pace. But I think your point's a good one. Even if you're doing that, and some of the data is from 2 or 3 or 4 years ago, is that good to use? And so there are some models where you do those kind of refreshes more often and closer to the current date. And when you can build confidence that what you have is sort of the current practices, not old practices, the more reliable it is. So we've had those kind of discussions. Brett's doing a lot of work on this model, and so there's a lot more work to do. But I think that's a key thing of how far back do you go, and can you keep sort of rolling the averages, keep building in newer stuff and dropping out older stuff, so that you're closer to current activities. So thanks.
Thank you.
I have a question about the data collection. So I guess it's as good as the data that's put in. So in looking at that one model, you're getting some stuff on MDJ, some things from the courts. And are you able to determine, like county by county, who's failing to report? And is there anything being looked into to incentivize those counties or educate those counties so that the data is more accurate?
I think there are some things along those lines in terms of the state drug treatment program, where we will be sort of evaluating the reporting on a county by county basis. I guess all I can say is right now there are big disparities in the data from county to county that would make it difficult to trust a model based on every individual county. So in terms of what we can do with the modeling right now, it's probably more realistic to look at the whole state or maybe clusters of counties. But in the future, yeah, we would like to clean up that data collection for all of the counties.
Thank you.
If there aren't any other questions, one of the things that I think may have been mentioned, I apologize if I missed it, was there's sort of two aspects to all of this work. One is the point the judge just made about data, the quality of data, the timing of the data, and so forth. So that's certainly a key to it. But with any kind of forecasting, you're also building in assumptions. So you're making assumptions about what you see as the profile of cases and the attrition of cases and things like that. And you're building that on past practices. But as the judge mentioned, things change. So sometimes you have to build in assumptions about how you think this is going to impact or at least accounting for it. And so one of the examples that I just received by text was COVID-19. I mean, think about the impact in the court system the past year because of COVID-19. So that's an unusual event, but that clearly is going to have huge impacts on how we consider the data from 2020 and how that's built into a model, or what assumptions you make to sort of work around that. So there's a lot of, it's, as Professor Mystic always says, it's art and science. And so the science part is the data and the quality of the data and working to really improve that. But there's a lot of art to it too, and that gets to the assumptions that are made that are as much policy and practice as anything else. So if there aren't any other questions, we can move to the next topic. Matt was, I know Matt was starting us off. Matt, was there anything else that we needed to cover on that?
No, I think that covers it, other than, thanks, Brett. I think the presentation showed culmination of 2 years worth of work into this project and also efforts to consolidate a lot of data from different data sources, be it from DOC or from AOPC and others. So just wanted to make sure that that was highlighted, those efforts, especially in collecting and consolidating that information.
Great, thanks. And Ryan, if we could go back to the other slides now for the policy committee slides. Great. So as I believe was discussed at the start, there are 4 topics that we're hoping to cover this morning. The first was the criminal justice population projections, and Brett just covered that. So the next 3 are the JRI certification of compliance, the academic review panel, which deals with the 8th Amendment guidelines or 8th edition guidelines, and then the parole guidelines and recommitment ranges. So on that second issue, the JRI certification of compliance, as a reminder, and we talked about this at the last meeting, under Act 114 of 2019, so that was one of 2 bills that were part of JRI 2, one of the requirements is that there's supposed to be a full submission of data to the commission. So when we talk about full submission of data, think about all of the guidelines we have in place and the other requirements. And so what's in play right now are sentencing guidelines, resentencing guidelines, and the sentence risk assessment instrument. And we did an assessment during the past year of, or based on 2019 data of sentences reported to the commission. And so here's how we did that comparison. We looked at AOPC data, Administrative Office of Pennsylvania Courts data. They have an application called CPCMS, Common Pleas Case Management System. And so within that system, all convictions, especially through common pleas courts, should be found there. And so we received data or checked data from the AOPC for all of the convictions that occurred during 2019 for misdemeanors and felonies from common pleas courts. So that was sort of what we were looking at from the AOPC point of view. And then we were trying to match that to what was reported through SGS Web, through our web-based application that courts use to do sentencing guidelines and report sentences to us. And you could look at this a couple of different ways in terms of what we call the unit of analysis. But what we decided to do was we thought the sort of the safest comparison was to look at the offense tracking number, the OTN, because an OTN may be applied to numerous counts in a criminal incident, but at least that allows us to know that that case was accounted for in both systems. So we looked at the OTN that was assigned to conviction offenses in the AOPC system, and then we looked to see if that OTN was found in our system. And we did this matchup for all offenses reported in ours and in AOPC. And so the difference were, underreported cases. Now maybe there was a reason for that. Maybe those cases were disposed of through, let's say, ARD, which might be a disposition type in AOPC. So we eliminated all those cases, those diversion program cases that aren't convictions for purposes of the guidelines. We also removed cases that involve merger because there could be, they could merge for purpose of sentencing and therefore there'd be a conviction, but there's not a sentence. So we tried to remove those. And whatever we found out in the end, that is what we reported back to the counties and back to judges to say, here's what we have. Are we missing anything? Can you explain this? Can you fill in the gaps? And so we gave courts the opportunity to do that kind of review. And then at the end of the process, those are the data we used to prepare the annual report for 2019. And that's the information that we also reported back to counties in terms of compliance with full reporting. So it was limited this past year for the 2019 year to sentences. But as we move to 2020, we're going to be looking at not only sentences reported, but also resentences following revocation of probation, and the use of the sentence risk assessment instrument that just there's a notation about any kind of action taken relative to the risk assessment. So, so that's sort of the background on what we've done, the process we have in place. We expect to use that same process in the coming year as we look back at this year, look back at 2020. And then during 2021, so starting in January, we're really working with courts to be really sensitive to what we're expecting from them in terms of full compliance. So it would be, every case for which there's a conviction in common pleas court, it's reported to the commission through SGS Web. And for any resentence following revocation of probation, that's reported. And then for any sentencing guidelines where the notation includes recommend additional information, that there just be a statement regarding whether the court did anything with that. Because remember, our sentence risk assessment identifies cases where we say we're recommending additional information because it's a high or low risk case, but it's really up to the court to decide what to do. So we're just gathering information about did the court do anything? So those are the three things that we're asking courts to be sensitive to make sure they're doing starting in January, because the reporting of sentences in 2021 will be used in the future to determine whether a county is eligible for funding. And so full submission of data is important. And when we're trying to do everything we can to provide information to counties about sort of the status right now, and to really prepare them for doing it the right way, starting in 2021, because that's where the full reporting is going to have some meaning in terms of potential funding. And the way that ties in is, if you look at the screen, Act 115 of 2019, that is the second part of JRI 2, and that's the part of the statute that requires or sets out the standards for this certification of compliance. And it says there's three things that should be considered by the commission when looking at or determining a certification of compliance. The first is compliance with the guidelines. And if you think about it, we have a number of guidelines in place, as I said, and even within the sentencing guidelines, there's a subset which are guidelines for the use of restrictive conditions, what we used to call county intermediate punishment. So we're going to be looking at whether courts are, complying with the guidelines, or at least considering the guidelines in these cases. The second provision of Act 115 is that we should be looking at other statutory requirements. So for instance, one of the requirements is courts are required to consider the guidelines in every case and to report the sentence to the commission. So that's certainly a statutory requirement. But the other one is that in order to use restrictive conditions of probation, the county has to have a county intermediate punishment plan and has to identify programs within the county that will be used as restrictive conditions. And then those restrictive conditions are subject to the guidelines for restrictive conditions. So it sort of all ties together, but those are the statutory provisions. And then the final provision under the Act is related to restitution collections. And this is really focused on making sure any kind of collections of restitution are paid out to victims, or any collections generally are paid out to victims. And I think it's a 50% threshold. Fortunately, the Administrative Office of Pennsylvania Courts, through that CPCMS application, has built into the system a mechanism to make sure that restitution is being paid at the percentage that's required by statute. So we think that most counties will be in compliance with the restitution collections because it's built into the CPCMS system. So I point this out that these are the provisions that we have that we're supposed to be taking into account for this certification of compliance. And we've reported information to the counties about submission of data and about a preliminary plan for a certification of compliance. And Ryan, if you could move to the next slide.
Hey, Mark, before you move on, can I just ask something?
Yeah, Judge.
So, like with the reporting compliance,
Mhm.
what's considered compliance? I know you're never going to have 100%
Right.
match up with AOPC convictions. So, is there a percentage you're looking at?
There is, and I'm really glad you raised that. Staff did a really great job. Ryan did a great job of trying to look at sort of what's the reporting of most counties. And in fact, we included in the meeting materials a spreadsheet that has sort of the breakout by county. What we found is, I don't know if it's a majority of counties, but a plurality of counties were above 95%. There were a number of counties that were 100%. There were some that were 99 or 98%. But I think at least a plurality of counties were above 95%. And we sort of see that as the first threshold. Something somewhere between 95 and 100% that should be considered full compliance. And then there were counties that were below that, but above 90%. And so maybe that's sort of the next tier. And then there were a number of counties in the 80% section. And I think that's getting, there's some gaps there that have to be addressed. So maybe that's compliant, but we have to consider that. I think if you drop below 80%, then there's really serious reporting problems, and I don't know that we could call that full submission. And so I think those are the categories we're thinking about, and we wanted to discuss with the commission in terms of where you draw some lines there. What is the appropriate break point for full submission versus not? And at least looking at the data, 95 and above or above 95 is, I think that's full reporting for sure. And then I think, the lower 90s and into the 80s, there's got to be some effort there because there's certainly some gaps. And when you get below 80, I don't think you can call that full submission of data. I think that's just different. It's a big gap. So
Sure.
We've been working with these counties to try to address or understand these issues, but I think more work's required.
And what do you do in a county like ours? And I'm not saying it happens here, but where the court is not the one submitting it, it's the DA's office. Then, if they wouldn't comply, I guess it's the court though that takes the hit on the funding.
Sure, and that's a really good point. And one of the things we've done during the past year when we were engaging with counties, doing all the county outreach, we went into that with the thought that the focus was going to be on risk assessment, and certainly we talked about that. And then JRI-2 happened, so we spent a lot of time talking about the JRI-2 changes. But a big takeaway that we really focused on in all of those county engagements was reporting requirements and use of SGS Web and standards in place. And one of the things we went back to was it is the court's responsibility. The court might not be doing it. The court might have authorized the DA's office or probation or clerk of courts to do it, but it's the court's responsibility. And so we were really looking to the president judge or the board of judges to really help to, look at policies and procedures and try to figure out how to address any kind of problem. So we continue to be available to, meet with counties and review those kind of things. But I think, at some point, I think the court has to take on the responsibility of looking at that and making sure whoever's assigned to the task is actually doing it.
Well, and hasn't there always been some type of requirement to report, I guess, but was it always tied to funding or not?
It was not tied to it. There's always been the requirement. As long as we've had guidelines, there's a mandate for courts to report. And look, some counties are great. We have really good reporting. Other counties not so good. And so we've really been, working to try to shore up those counties that we see underreporting. and part of it we find goes back to this like oversight. You know, if an agency or an office is assigned the responsibility, there just has to be a mechanism to make sure they're doing it. So, you know, a number of years ago, the commission started to provide specific reports to every judge about, you know, these are the cases that we have reported from you. Here are the reasons that were given for departure or whatever. Here's your opportunity to review this, add anything that's missing, correct anything that's wrong. So we've had that verification process in place for probably a couple of decades. I mean,
Well, and that leads to my next question, I guess. I know reporting is one thing, compliance with reporting, but then compliance with the guidelines, obviously something separate. Is there a requirement of compliance with the guidelines to receive funding?
yeah, I think the compliance with the guidelines, I think it's a broader definition, at least in my view. I think it's, are you complying with the rules? Like, for instance, the guidelines are advisory.
Right. So if I depart,
Mitigate, aggravate, or depart. But when you depart, you have to provide a reason for the record. So I think if there's a departure, you know, what was a reason provided? So that's one example. But the other thing that I think is a little bit different now than prior to JRI 2 is that eligibility for the use of restrictive conditions of probation is linked to the guidelines. So effective January 1st, under the Amendment 6, the guidelines for the use of restrictive conditions are actually part of the eligibility criteria for the use of county intermediate punishment. So I think that's more in terms of intensity and duration, right? Like here's a case that's basically a straight probation case, and the person's being placed on restrictive conditions for a year. You know, that would be certainly outside the guidelines, but it would not be, you know, from an eligibility point of view, it might be called in question unless the court said, oh, but the reason I did that was X, Y, and Z, and then it seems to make sense. The other part of that is, again, this interplay between Chapter 98, the County Intermediate Punishment Act, and Chapter 97, the sentencing provision, where there's where the county has to identify and sort of select programs saying, okay, in our county, we're going to have house arrest and electronic monitoring as a restrictive condition. And then at sentencing, the court is authorized to use those programs. But if the county doesn't have a plan or hasn't identified house arrest and electronic monitoring as a restrictive condition, then it couldn't be used at sentencing, because for that county, it doesn't exist. There's not sort of the framework that goes with the county IP plan. So those are, you know, they seem sort of very, you know, detailed kind of things, but I think that is just different now than it was before JRI 2 was enacted.
well, tying it to the funding is going to get people's attention. I think that's the biggest difference.
Well, and I think that might have been part of the purpose for the certification of compliance. It was, you know, if we're going to, you know, if we're going to sort of simplify and streamline processes and allow sort of more straight use of probation with restrictive conditions, there should be some mechanism to promote best practices. And part of that is the funding part. So.
Thanks.
You bet. So if we could go to the next slide, and I'll try to be pretty quick about this, and it's very small font, but this material is, this document is in your materials, and this is in effect the draft that we had during the last meeting, but I cut out a section of it that sort of focuses on these two issues. The one is full submission, and the second is actual certification issues. So in response to the question from Judge Marsico, the first part of that where it says full submission really does get to what are the thresholds. And as I said, when we look at the reporting and just sentencing reporting, not resentencing, not risk assessment, just sentencing, we found that, you know, many counties are in the 95 to 100% band, and we would see those as being in full compliance. I think we do see these other categories. We see less than 95% or 95 and less down to 90 would be sort of medium. They're compliant, but like a little bit of work is required. And then those that are in the 80% range, we think are low performers, but perhaps they weren't reporting, full reporting, but require work, and maybe the following year they wouldn't be compliant if there's no improvement. I don't know. It's call of the commission. But I think when you get below 80%, then there's I'm not sure that we should identify those as full reporting counties. I think that would be a non-compliance in terms of full reporting. So that's an issue. We can certainly discuss it now, where I just wanted to present it to you, and if there's support for a sort of a bright line threshold between full submission and not full submission, I think that break that we'd see is 80%, but members could think it should be higher, like 90%. So I'll just pause and see if there's any other comments or suggestions about just the level of submission.
Will there be, I have a question.
Sure.
For the people who historically have been low, is there any kind of a step up? Like we expect a jump from this compliance from 72% to 85%, or, I mean, I guess the people who are, the 95 and above, they're already good. And then we have that other window of people. Is there something that we do in the intermediary to incentivize or recognize the improvements for people who are low reporting?
Sure, Judge, I think that's a great idea. Sort of incentivizing is wonderful. I know, as I said, staff has really been working to some degree target those counties, to really reach out to those counties and see if there's something we can do to help, or just meet to sort of review and try to figure out what the process is and where cases may be falling out that need to be part of the mix. I know when we did a sort of a verification process, probably 20 years ago, but maybe not that long ago. But when we were going through this process, trying to sort of figure out county practices, we found there were some counties where they just had like systemic issues that created underreporting. Like if a case went to trial, there was no one doing a guideline form. And so all the cases that went to trial didn't have a guideline form, versus there was a great process in place for guilty pleas. And so when we worked through that with those counties, we were able to really address that gap. Or maybe DUI cases were a separate track, and they weren't, guideline forms weren't being done. So we addressed that. Sometimes it's there's a new judge in criminal court and just doesn't know that there's a requirement to report. So we've tried to address some of those issues in how we report back to the counties each year, by not only providing information to each judge that we have sentences from to say, here's what we received, are there any others, are there any errors, but also providing a summary report to the president judge or the administrative judge to say, here's what we've received from your county, and these are the judges. Because if there's a judge missing from the list that's doing thousands of cases, well, the PJ or administrative judge would be able to identify that and act on it. So those are some examples of what we can do. But Judge, I think you're right. If we can build in any kind of incentives in what we do, that would be great as well. I think it would promote better practices.
Mark, I'm just curious, does this system account for dispositions in problem-solving courts or specialty courts?
Yeah, Professor, it does, or it should. And I think that is one of those things where we have to work with counties, because, depending on the problem-solving court, some courts are based as pretrial diversion programs. So we wouldn't receive those cases anyhow. They're effectively ARD or Section 17 or Section 18. So any kind of disposition of those cases wouldn't come to us, and we'd be filtering those out when we do that comparison with AOPC. And then there might be back-end cases where you have a problem-solving court that really is at the parole or reentry phase. And,
Right.
and of course, those are outside of the scope. So we're just looking, at those problem-solving courts that focus on sentences for convictions. But you're right, there are some counties where when placing someone in the program, they may not be in the practice of saying, "Oh, I'm placing you on probation," or something like that, where they're not identifying a specific sentencing alternative, or they're not completing guidelines. So that's really, I think you're right, an opportunity just to make sure we're not missing anything there, because it might be one of those sort of systemic
Okay.
gaps. But I
Thanks,
think
Mark.
problem-solving court's a good example. All right, let me just move to the next part then, which is certification of compliance. And again, this is, we're looking at various things, as I discussed with Judge Marzico. When we talk about compliance with the guidelines, it's really playing by the rules of the road, not necessarily giving a sentence within the standard range, right? It's, if you're not giving a sentence in the standard range, providing a reason for it, reporting sentences to the commission, considering the guidelines in all of these cases, and the risk assessment. So those are the key provisions there. To sort of bring this to a close, because we have other things to discuss, what the staff is looking for is any sense from the commission of thresholds. So for full compliance, for full reporting to the commission, what's the sort of the bright line that if you're below that, you're not reporting, if you're above that, you are. And as I said, I think at least initially, we see some merit to saying 80% is sort of the bright line this year. We'll try to work with counties to bring them up, from below 80 to above 80, from below 90 to above 90, from below 95 to above 95. So maybe use the next year as a transition year to really try to improve practices. But then, at some point, maybe raising the bar, because we really do think that sort of the standard we should be looking for is 95% or greater compliance. But this is a process. And so, starting in a way that we can incentivize or encourage counties to improve practices is probably a good starting point. So, so that's one thing to think about. And then the second is there a threshold, or what is the threshold for the certification of compliance? Because this is a all or none proposition. If the commission does not certify a county for the use of restrictive conditions of probation, that county cannot receive funding from the state. So the commission's decision about certification of compliance directly relates to the county intermediate punishment funding. Now, there's other funding available, and that's not impacted directly by the commission's decision about certification. But if the commission does not certify a county as compliant with the use of restrictive conditions of probation, that county cannot receive CIP funding during that year. So I bring that to your attention because the commission will have to decide, what is that threshold? What do we say is the sort of the pass-fail line in terms of certification of compliance? And the factors we'll be looking at are the ones that we've talked about in terms of complying with the County Intermediate Punishment Act and other things like that. So we don't have to make a decision now, but I wanted to bring that to your attention. We can talk a little bit about it during the business meeting, try to make any kind of decision there. But we're hoping, into the new year that we can provide information to courts about any kind of thresholds that are in place. If there's no other questions on that, we'll move to the next topic. Okay. So the two remaining topics are the academic review panel and the state parole guidelines and recommitment ranges. So I'll start with the academic review panel. And as far as members, I think we have a slide with the membership that we'll bring up. And I just want to say, you know, as background, you might recall during the last meeting, a decision was made that Representative Stevens would appoint members to this academic review panel. The purpose of the panel was, there were a number of purposes, but certainly one was to have an outside review of the work we've done so far on the 8th edition guidelines, to have another look at it before we really dive into actually putting drafts out for public review, building towards that point. So the idea was to look at experts, subject matter experts in sentencing guidelines. And then this was a great opportunity to take into account issues of race and ethnicity, disproportionality in sentencing, issues related to both our prior record score and sort of aggregate sentences, concerns we've heard about, over incarceration or overuse of community supervision. So we wanted to have experts in the field as part of this panel to just look at those things before we move forward. Really fortunate to have Judge Tucker serving as chair of this academic review panel. The commission, it's hard to see this list of members, but we have it in your materials. But we tried to identify subject matter experts in these many fields from Pennsylvania universities. So we certainly were looking at the state-related research universities. We were looking at the historically Black colleges and universities in Pennsylvania. And we were looking at the schools that we are affiliated with or have MOUs with. So the Villanova and Duquesne Law Schools and Penn State. So that was sort of the core in terms of making sure we had representation from Pennsylvania colleges and universities and from different disciplines and views in that. And then outside of that, we looked at experts from across the country. So we have a law professor from the University of Minnesota. We have a criminology professor from Arizona State University. We have a former staff member of the United States Sentencing Commission who also had been the executive director of 2 state sentencing commissions. So we pulled together, I think, an incredibly diverse and thoughtful group. We have Judge Tucker as the chair, and staff has been supporting this effort. We've had 3 meetings to date, and that was sort of the promise. We recruited people and asked them to commit to 3 meetings, and we've had 3 very good meetings. The materials and the recordings of the meetings will be available to commission members, so we'll give you a link subsequent to the meeting in case you want to look at the proceedings or any of the documents. And again, this is just intended to give us a grounding before we move into the full work on the 8th edition sentencing guidelines. We are clearly looking at the information or the proposals that were put forth by the strategic planning work group and the other work done by the commission related to that. And we're looking at research that has been done in Pennsylvania and about Pennsylvania guidelines. And then I think importantly, we're looking at some other issues that we haven't touched. So we've talked a lot about prior record score and about the need for lapsing provisions, sort of dealing with stale records or removing those from the prior record score. But we really haven't talked about like a fundamental review of the prior record score, about what we count and how we count it and how much weight it has in terms of sentencing. So those are issues that we're really trying to unpack as part of this process. So we had 3 meetings. That was the commitment of members. We offered opportunities to continue to engage with the commission, either through additional meetings or through reviewing drafts as we move forward in the new year, partnering with the commission on research projects, either really short-term projects or longer-term ongoing projects. And I have to tell you, we had overwhelming positive responses from members about staying engaged with the commission. So I think this helps to address issues and concerns about diversity. It addresses expanding the relationships the commission has with colleges and universities in Pennsylvania, and the idea of really linking with research partners around the country. So I think this has been, a really good start to this process. And Judge, I don't want to put you on the spot, but Judge Tucker has led this effort, and we appreciate all his time and effort. If there's anything you wanted to say at this point.
Oh, no, I just appreciate the privilege of the chair appointing me as chair of this particular academic review panel, and the insight that these professors are bringing, the information I think is to me is astonishing. I mean, it helps think outside of the box. I think we're so used to doing this every day. They see things perhaps from a different perspective and add value to what we're in fact doing. So again, I consider it a privilege, and I thank the chair for appointing me as chair of this panel.
Thanks, Judge. So I think that's all I wanted to cover on that, but I wanted to open it up for any questions or comments, and just to assure you that we'll continue to work with these individuals. But I appreciate the chairman appointing this academic panel. I think it's been just a really positive thing, and I think it will bear fruit in the future as well.
Mark, can I just add? Let me see if I'm unmuted. Okay. Just because we talked about this yesterday, there were 2 notes that I wrote down that I thought might interest people. In terms, you talked somewhat about the diversity of the makeup of the group, in terms of like where they're from and their walks, but also in terms of gender and ethnicity. It's a really pretty fabulously diverse group, which is exciting. The other thing is that you had just indicated, and maybe you said this and I missed it, but you had recorded each of these sessions, so if people were interested in seeing what it looks like, that's available, correct?
That's correct. We told the members when we started, the members of the panel, that it was these were like internal discussions, but that we would like to make the recordings available to commission members as we're going through this, and they agreed to that. So yes, we'll provide a link to commission members to be able to view the proceedings.
Thank you.
Thank you. I will mention that although we've spent a lot of time when we're talking about the 8th edition guidelines in terms of just structural issues, streamlining the guidelines, being more purposeful in terms of, what are we trying to achieve, building in a lot of the JRI 2 recommendations about more focused recommendations and less weight in the prior record score, having more certainty in the guidelines. So all of those are in play, but an issue that we've been looking at very seriously is the impact of race. And the commission has done a lot of research and partnered with a lot of researchers to look at race and sentencing. But oftentimes that focuses on outcomes, disproportionality in the correctional population or at sentencing, things like that. What this has really provided an opportunity to do is look at structural issues built into the guidelines. And one of the examples, and we've done research on this, but I think it just became very clear in our discussions with this group, was if you just look at the guidelines and the prior record score, just the way we count things and the idea that we have no lapsing in place. So there's a legacy of convictions that doesn't go away. And because of concerns more generally about disproportionality in arrests and convictions, people coming into the system retain that criminal history, and that shows up in the prior record score. And so one of the things that was very clear from just our discussions and the research we did for this project was seeing how just based on the prior record score, the disproportionality increases as you move across the prior record score, as the prior record score increases. It also increases as you go up the scale in seriousness of offense. So these are structural issues. And some of these issues we, especially on conviction offenses coming in for sentencing, we have limited ability to impact that because they are the cases coming into the system. But where we have a huge ability to impact the system is what we do with criminal history, what we do with prior record score, how we address that in both terms of use of confinement or community supervision, but also in terms of disproportionality of race and ethnicity. So those are things that that have been focal points of our discussions, and that's going to go forward. But I think that's a huge addition to the kind of work we've done before, where we're focused on sentences, and this is a much more direct focus on race and ethnicity. So more to follow, but thank you for empaneling this group, and as I said, a really positive experience. Well, with that, we'll move to the final topic, which is the state parole guidelines and recommitment ranges. As you might recall, over the summer, we had, I guess back in June of this year, the commission approved and published initial state parole guidelines and recommitment ranges. And we had public hearings, including a public hearing with the Department of Corrections involving individuals at SCI Benner, Rockview, and other facilities. And then during the September commission meeting, we talked about some of the takeaways from those public hearings. And the commission decided to pause at that point instead of adopting, and continue a review until today's meeting. And some issues got in the way along the way. So let me explain a couple of things and reasons why we want to delay further. The parole guidelines that we developed have two main components. One component is risk assessment, and the other component is preparedness, readiness for release to the community. And so on the risk assessment side, the commission is required to use a risk assessment, a validated risk assessment, as part of the parole guidelines. So we have to do that by statute. And when we looked at the instruments that were available and used by the Department of Corrections and with parole eligible candidates, the best in use in the Department of Corrections when we did our research was the LSIR. And so we built that into the draft parole guidelines. We did all the calibrations and thresholds based on domains within that instrument. And that's a really important part of the parole guidelines. But we knew, and we've had discussions for years with the Department of Corrections and the Parole Board about the risk assessment instruments they were using. And there was consideration throughout this period of time of moving to a new fourth generation instrument. And there were a number that were being considered, but subsequent to our meeting in September, the Department of Corrections decided to move forward with the use of the Strong R. And that would replace not only the LSIR, but some of the other risk assessment instruments used by the Department of Corrections. Now, it's not in place yet. And even as it's being sort of built or modified to address the state prison population in Pennsylvania, it has to be validated as well. And we, for our guidelines, can only use a validated instrument. So you can see we're sort of in a pause right now. LSIR is still being used by the Department of Corrections, but it's not going to be used in the future. And if we're talking about state parole guidelines going into effect a year or more out, it's likely the LSIR will not be in use. and strong R may be the instrument, but it's not ready for prime time yet. It hasn't been validated yet, and that process is underway. And we won't be able to figure out how to build that into our parole guidelines until they finalize the instrument and it is validated. So you can see we're at this sort of standoff. We think there's a lot of promise about the strong R, because not only is it helpful in terms of risk and needs, which is an important characteristic, but perhaps even more important, the third category, the responsivity, the case management planning. Because we talked before about if it was available, we thought the information on responsivity, on case management, could be critical in terms of identifying the conditions of parole, because there was a concern expressed about over-conditioning parole, putting too many conditions or inappropriate conditions on individuals. And the strong R is really built to try to identify what the needs are and what type of case management plan should be in place. So we think that's very complementary, could be really helpful within guidelines to take full advantage of the strong R when it's deployed. So I bring that to your attention because that really does lead to sort of a delay in any action. And we'd recommend as staff that we delay action until we have, a clear understanding and are ready to be able to incorporate strong R into parole guidelines. But that allows us to also think about some other things that are in play. The next I have listed is harmonizing with other guidelines. And I'll give you an example of this, and this has to do as much with the recommitment ranges as anything. But under the sentencing guidelines, under the 8th edition sentencing guidelines, one of the things that we had been talking about was building into the guidelines an enhancement or an adjustment if someone is under supervision at the time of an offense. But if you think about it, our resentencing guidelines take into account or provide a higher recommendation if someone commits an offense as a violation of probation, and the recommitment ranges take into account or give higher recommitment recommendations if someone has been convicted of an offense while under parole supervision. So if we're not careful, if we don't harmonize our guidelines, we could be providing a penalty, a sanction, a recommendation for more sentences, both at sentencing and at recommitment or resentencing. So we want to do what we can to avoid sort of a double hit. And it seems that the better approach would be to focus on any kind of enhanced recommendations as part of that resentencing or recommitment, and strip that out of the sentencing guideline proposals that we have. There are other things that we found, and especially in our discussion with judges and with the parole board about recommitments. And this was that if someone has been released on parole and while on parole is convicted of a new offense, there is no consistency in how the decision about recommitting the person on the current parole violation and the decision about what sentence to impose for the new conviction offense, there's no consistency in how those are addressed. So in some cases, the judge will go first. The judge will sentence on the new offense, and then the parole board will take action on the recommitment. And in other cases, it's just the opposite. And more often than not, both parties are looking at the other, trying to figure out who's going to go first and what they're going to do. And then that's somehow calibrated into the decision the second actor makes. And so what we've discussed with the parole board is there would be a lot of benefit to impaneling or bringing together a group involving the rules committee and the board and sentencing judges and others to try to sort of figure out, is there a consistent process that should be in place to try to address these issues? And that could impact what we do or what we include in the recommitment ranges under for parole. So I'm just throwing all that out to say there's a lot of stuff in motion, and I think, you know, a pause on moving towards adoption is probably warranted. The final thing that I'll throw into the mix, and this certainly applies to state parole guidelines and recommitment ranges, but it also applies to the 8th edition guidelines, is keeping in mind how wedded we are to technology. And, you know, we have SGS Web as an application for sentencing guidelines and resentencing guidelines and risk assessment. But when we rebuild guidelines or we create entirely new guidelines like for parole or recommitment, there's a lot of work that goes into the programming, the building, the architecture of that entire enterprise. And so anything we do in any of these areas, we have to keep in mind that it's going to take a while to put that in place so that courts or paroling authorities have access to information and to an application where they can calculate the recommendations and they can report the decisions to us. So we have a lot of work to do, a lot of coordination to do with the parole board and the Department of Corrections around state parole guidelines and recommitment ranges. After we decide what they are, after we decide the guidelines, we still have a lot of work to build that application, build that exchange of data electronically. And the same will occur when we redo the guidelines, when we do the 8th edition. We're going to have to build that capacity. And so today during the meeting, we'll talk about, you know, the next couple of budget years and, you know, what we need to do as a commission to make sure we have the capacity to do these kind of things. But I wanted to at least call that to your attention as we were talking about parole guidelines. So with that, a lot of rambling, but I think I'm open to any questions, but otherwise we can start to wrap up and maybe take a break before the start of the commission meeting.
Mark, I have a quick question.
Sure.
As it relates to the interplay between the state parole guidelines and the risk assessment instrument that the board utilizes.
Mm-hmm.
I guess I'm concerned if they were to then change their instrument again, does that mean we have to revisit and revamp our guidelines again? Are we too tied into whatever instrument they're using is my question to you.
Yeah, well, I guess the short answer is yes, but I think there's good cause for that. So unless we were to develop or adopt a specific instrument and then by some means require the Department of Corrections and the parole board to use that instrument in addition to anything they might already have, you know, if we weren't going to go down that path, then we have to sort of figure out what it is that they have in place that they're using and take advantage of that we're sort of the recipient of the work product already in place. So I think we've over time have thought that latter approach was better, that we're respectful that, you know, the DOC and the board, you know, have identified an instrument that works well for their purposes, and we should just try to take advantage of using that information for our work. Now this transition to the strong R is, I'm not going to say once in a lifetime, but it should be rare because it really is a huge undertaking. It's gonna, you know, they're not just like grabbing something off the shelf and putting it in place. It's being developed and you know, sort of detailed for this population in the DOC. So it's expensive and it's also very specific to the DOC, which is why it's going to take some time to roll out. But once it's in place, you know, they want this to last for a long time. So I don't think we're going to have to worry about, you know, them jumping off the strong R anytime soon. But I think there is a concern if we go with LSIR right now, we would sort of miss the boat as far as them using a different instrument in the near future.
Yeah, I wasn't trying to suggest we stick with LSIR. I was more or less wondering whether we needed to be tied to any specific risk assessment instrument or whether there's a way to avoid that, but it doesn't sound like there is.
Yeah, I think that, the statute requires us to use a validated risk assessment instrument. So if we don't use theirs and their validation, we're going to have to, develop our own. And it's not that we don't know anything about developing risk assessment, but we know there's a lot involved. So, and also, look, I think, we're trying to look for ways to really better coordinate the system, have a better flow of the system. And, we're part of that, but, this is their space. And I think if we can, find a way to coordinate with them, I think it helps a lot. And also keep in mind that as we're developing the parole guidelines, a parallel track is happening at the parole board where they are updating their internal instrument, what they call the 361. And really what we're hoping is that the parole guidelines and the 361 are sort of one and the same, except that, as you would expect, the parole board will have much more information, much deeper information, much more confidential information than we would have in the guidelines. But you could see the guidelines is almost, the cover page, and then they would build out from that on the back end to really supplement with other information they have to sort of score the guidelines. So, and one example of that is, we're required to consider victim impact, but we're not allowed to assess that because we don't have access to confidential victim information, but the board does. So if we in the guidelines build in sort of a space for consideration of victim impact, and then the board, when looking at an individual case, is able to take into account specific and confidential information to answer those questions, I think that's a good process. We're collaborating and working together, and we're doing sort of the public side of it, and they're doing, sort of the internal side, but they'd be consistent with one another. So that's the goal. And I think the same would apply with risk assessment and other things.
All right, thanks.
Thank you. Any other questions, comments? All right, Judge Bernstein, I'll turn it back to you. I think we actually are going to have a little breathing time between now and the start of the meeting at 11. Hey, Judge, you're muted.
That was my second time. I said it's usually 2 times the Zoom meeting, so I've used them up. Yeah, so we're good to go. And then I guess we'll just reconvene. Everybody kind of be signed on a couple of minutes before 11 so we can start.
Sounds great.